Hello and welcome to a special episode of Legal Wrangle on Direct Tax. Special because in this episode, we bring you 6 important cases relating to landing and parking charges of foreign airlines, treatment of advance received from land developers, interest on advances made to a subsidiary, deemed income found during search, issue of depreciation and conversion of survey proceedings in search operations. Our first case is an interesting Supreme Court decision where assessees are foreign airlines. The question involved here is whether the landing and parking charges paid by foreign airlines to Airport Authority of India are similar to charges towards use of land and tedious obligation under Section 194I arises, or are they in compliance with various international protocols and thus attract provision of Section 194C? Let's hear some more facts from Prabjot.
SSC provides inward and outbound air traffic services to and from New Delhi. For landing the aircrafts and parking thereof at New Delhi Airport, the Airports Authority of India levied charges on the SSC, for which the SSC airlines were deducting TDS under Section 194C at 2%. The income tax authorities, however, took the view that the TDS was to be deducted under the provisions of Section 194I of the Act, which called for deduction at 20%.
The Madras High Court in case of Singapore Airlines Limited had held that the facility given by the Airport Authority of India was not of use of land per se, but the charges on landing and takeoff were in respect of number of facilities provided by the Airport Authority, which was to be necessarily provided in compliance with the various international protocols. The substance of these charges was ingrained in the various facilities offered to meet the requirement of passengers, safety and parking of the aircraft. The Apex Court thus held the conclusion of the Madras High Court as against the Delhi High Court decision. Thus, the Supreme Court concluded that the charges paid by the airlines for landing and parking were not for use of land, but for various other facilities extended by the Airport Authority of India to the airlines. Use of land in the process becomes incidental. In our second case, the assessee, DLF Commercial Project Corporation, is a firm in the business of developing land for commercial and residential purpose. The question involved is whether when the sale of development rights is recognized on accrual basis in accordance with the terms of the agreement entered with customers, every receipt can be treated as income of the assessee. Prabjot has the details of this case.
The assessee had entered into an agreement for development of land, and in pursuance of that, it has also made advances to certain land-owning companies that acquire licenses from relevant state authorities and landholders. These companies had treated such advances as stock. The AO therefore treated the amount received in the form of loan as sale for the purpose of determining total income. On appeal, both CITA and tribunal ruled in favor of the assessee.
The High Court also favored the assessee by holding that without acquisition of land, the assessee could not even apply for the approval from the town and country planning authorities. Therefore, by no stretch of imagination, it can be said that there were any development rights in existence at all during the year with the land-owning companies. Thus, there was no question of any such rights being transferred, as the advances received by the assessee were linked with the proper conveyance deed, and the assessee had not sold any such rights. The advances received could not be classified as income. In our third case, the issue is whether interest received by an assessee from borrowings by its sister concern can be allowed as deduction if such financial assistance was out of utmost necessity. The assessee is Bright Enterprise Pvt Ltd, engaged in the hotel business. Let's have the facts from Prabjot.
The assessee had paid an amount as project advance to its sister concern and claimed deduction on interest received from it. The AO denied the deduction by holding that there was nothing on record to show that it was commercially expedient for the assessee to make such advances to its sister concern.
The High Court noted that the subsidiary had to be funded to a large extent, otherwise it would not have survived. And if it had gone into liquidation, the assessee would have suffered directly on account of an erosion of its entire investment in the subsidiary. The High Court thus held in the favour of the assessee and concluded that when a holding company invests amount for the purpose of the business of its subsidiary, it must be of necessity and is to be held as an expense on account of commercial expediency. Looking through the lens and freezing the moments for life, a fleeting glimpse that is now framed to be seen by generations. Caressing the canvas with gentle strokes of vivid colors, drawing lines that intersect each other to form an abstract that holds more meaning than defined shapes. Striking a note that invades the hearts deep down, filling them with pathos and elations, a song and tune that lingers on our ears forever. Touching the lives and holding the hands of people who were bereft of compassion that should have come from the society that they are part of. There are many stories around us, but the most fascinating ones are those that are not really aligned to the kind of work they are associated with, which involve tedious tax assessments and solving the quagmires in law. We are talking about the taxmen who went on to excel in the fields of photography, painting, music, NGOs and entrepreneurship and much more. Once aspiring to be part of the civil services and conquering it to serve their nation, they became the important cogs of the giant complex wheel of taxation and bureaucracy. As India unfurls the tricolour on August 15th, TIOL Tube brings to netizens a rendezvous with some of these gems. In a new program, Life Beyond Tax, success stories of taxmen going that extra mile. In our next case, the assessee Ajay R Dhoot is an individual. His premises were searched under section 132, during which a locker key was seized which belonged to another individual staying with the assessee. The bone of contention in this case was whether the market value of jewellery stored in another individual's locker may be added as the assessee's deemed income under section 69A. Let's go to the case details.
Revenue rejected the assessee's explanation that the jewellery was a gift received from his aunt and stored in another person's locker. Consequently, Revenue added the value of the jewellery as the assessee's deemed income under section 69A. The tribunal confirmed the order and further held that, in terms of section 69A, the financial year in which an assessee was found to be owner of any jewellery for which no sufficient explanation was offered, then the value of such jewellery can be deemed to be income of the assessee in such financial year in which the jewellery was found.
The Bombay High Court concluded in favour of the revenue by holding that it was only on opening of the locker of another assessee that the revenue found the jewellery, a part of which belonged to the assessee. It also held that the theory of gift cannot be applied in the case of an asset seized during search. Our second last case is about entitlement of depreciation on land and building vested in municipal body when assessee has made part payment to housing board towards the same. The assessee is Bharat Hotels, a joint venture between Delhi Automobiles and NDMC. Let's hear the case details.
Assessee had entered into an agreement with Delhi Automobiles, which anticipated the transfer of license in respect of land to the assessee. Under that agreement, assessee had the right to give out spaces in the building to sub-licensees. The AO disallowed the depreciation claimed on this land and building by holding that the assessee was not the owner. It had made part payment to the housing board and the title had not yet been transferred in its favour. Both CITA and the tribunal decided that the assessee had domain over the property as it was utilizing the same.
The High Court answered in favour of the assessee. Considering Explanation 1 to Section 32, the High Court held that the assessee had control of the property, which itself was sufficient to allow depreciation. In our last case, the High Court considered a rare issue, whether a survey initiated under Section 133A can be converted into a search action under Section 132 merely on the basis that huge cash was found during the survey operations. Let's have some more facts.
The revenue officials entered the registered office premises of the assessee during daytime for conducting a survey under Section 133A, during which they seized huge cash and also impounded books of accounts. Assessee argued that the survey conducted under Section 133A could not be converted into a search under Section 132 without any warrant or authorization to search premises under Section 132.
The High Court held in favor of the revenue by concluding that the CBDT has issued instructions in September 2014 indicating that where undisclosed cash of more than rupees 10 lakhs was found at an assessee's premises during survey under Section 133A, the DIT of investigation having territorial jurisdiction over the survey had the right to examine facts to take recourse to Section 132(1). Well, this brings us to the end of this episode of Legal Wrangle on Direct Tax. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. It's free and will keep you updated on our new posts. Have a good day.